Morning. The next case is the estate of Romig versus Boulder Bluff condominiums. This is a 15-minute mini oral argument on the application. Mr. Woofter, are you handling the argument? You may reserve time if you like, and if you're ready, you may proceed.
Thank you, Your Honors. May it please the Court, I'm Daniel Woofter, appearing on behalf of the plaintiff's appellants. This is a very straightforward disability case. My clients requested that they be able to install a handrail at their own expense to accommodate a resident's disability, and the defendants arbitrarily denied that request. The principal question before this Court is whether the Plaintiffs with Disabilities Civil Rights Act protects people with disabilities even after their sales transactions are consummated. According to the lower courts and to the defendant association, it is not. And so a condo association is essentially free to deny reasonable accommodations for disabilities that emerge after a resident takes possession of a condo unit. That isn't right, and in fact, multiple statutes prohibit refusing to make accommodations in circumstances like this. First, any such refusal violates Section 506A, which prohibits any person from refusing to permit reasonable accommodations in connection with a real estate transaction. Here, the prohibition on adding handrails is contained within the sales documents themselves. The master deed prohibits modifications to units without the written approval of the association. Thus, the association's denial was surely in connection with, that is, depended on, involved, and followed from the sale of the condo as dictionaries define that term. But for the prohibition in the deed, my clients could have installed the railing without the association's permission. Second, defendant's conduct violated Section 502B, which prohibits persons engaging in real estate transactions from discriminating against a person with disabilities. In addition to the sales transaction just mentioned, my clients made ongoing regular payments of association fees in exchange for the association's continued management of the co-owned property. If my clients were to stop paying their condo fees, they would surely lose the right to own and possess their condo, just as a renter would be evicted for failing to pay their rent. The statutory text also explicitly protects a person residing in or intending to reside in a dwelling after it is sold, and reading the statute as the lower court did, and as defendants would have this court do, would render that language superfluous. Finally, defendants' conduct violated the Condominium Act. This claim is not before the court, but defendants have tried to use its availability in this case to shield themselves from liability under the civil rights laws. The court should not be misled, however, into thinking that the Condominium Act comprehensively or effectively addresses disability issues in condos. Instead, that statute applies only to accommodations for mobility-related disabilities that make it harder to get into and out of the unit. It does not address other kinds of disabilities, and it does not address the right to use the common areas that are not related to the unit. The remedies available under that statute are also narrower than the remedies under the civil rights laws. So although we have a claim under the Condominium Act, that is not a reason to refuse to interpret the civil rights laws in accordance with their plain text and remedial purpose. Quickly, I would like to just address the mootness argument that was raised by the defendants. There is no question that this case is not moot, and indeed, defendants don't actually make a mootness argument. They make a collateral estoppel argument. Collateral estoppel, though, is an affirmative defense that has not yet been asserted by the defendants in the proper course, so it is impossible that this can make the case moot. In any event, collateral estoppel cannot apply here because for a defendant to succeed at proving collateral estoppel, the defendant needs to prove equivalency. That showing cannot be made before this court rules on that issue because this court can always accept an argument that as a matter of law, the state provision does not require the same summary judgment legal conclusion that the Sixth Circuit came to, even based on the evidence in that case, which is of course not before this court or in the state record. If this court believed that defendants' collateral estoppel argument might bear fruit, it should resolve the questions it asked the party to brief and then remand for further proceedings. Defendants can then...
Let me interrupt you, counsel, but so just so I understand, I hear you to say you don't think the claims are collaterally estopped by the Sixth Circuit's decision, but if we disagree, is the case moot?
No, Your Honor, it would not be mootness. Collateral is, if you lose on the merits, it doesn't mean that your injury was redressed. It just means that you would still have an injury and that claim could be redressable by the court. It would just be decided that no, the defendants met their affirmative defense. That's different than mootness, which means that the court cannot provide relief that the plaintiff seeks.
But if the claim is collaterally estopped, we can't provide relief, right? I'm trying to understand the relationship between collateral estoppel and mootness.
Let me try it this way, Your Honor.
Thank you.
Collateral estoppel, as I said, is an affirmative defense, and it hasn't been asserted. A claim can't be collaterally estopped unless that affirmative defense is made in the proper course.
But I understand that they've tried to make it, they tried to make it in the trial court, they tried to make it in the Court of Appeals, and they weren't able to. And if we believe that there's something to it, what do we do about that?
Maybe I'm misremembering the record, but I don't think that they tried to make that argument below. I believe that argument only arose after the Sixth Circuit rendered its decision, so they haven't been able to make it in the circuit court case yet. And so in all of the cases that the other side cites for the argument that this is moot because collateral estoppel applies, collateral estoppel was asserted in the normal course. A motion for summary affirmance was made on the basis of that affirmative defense in circuit court. Either the circuit court or the Court of Appeals affirming, or the Court of Appeals decided that that collateral estoppel defense was met. It had been proven, as is the burden of the defendants. In that case, they didn't resolve the issue on mootness grounds. They resolved the issue on collateral estoppel grounds. Mootness is a completely separate doctrine that goes to whether or not their injury exists and the injury still exists and is redressable by the court. So to cross the T and dot the I, the proper course would be for this court to allow that, if it thinks that there might be something there, that might bear fruit, it should resolve the issues that it asked for additional briefing on, remand to the circuit court, and allow, if the defendants at that point wish, to assert their collateral estoppel defense in the normal course. And then it can come back up through the way that it's supposed to procedurally occur. They should not be making an affirmative defense for the first time in this court, and certainly not when there's no fact, and certainly not on the basis of facts not on the record here. I would like to reserve the remainder of my time, if I may, unless there are other questions.
Before you do, let me just ask one question about the statute itself. If the legislature was interested here in creating some sort of ongoing obligation of making accommodations with respect to housing, why did they tie the Section 502 and Section 506A, why did they tie that obligation to the real estate transaction itself? That would be a strange way to create an ongoing obligation, would it not?
I'll start by saying that 506A doesn't tie it directly to the real estate transaction. It says in connection with a real estate transaction. So it doesn't have to be the real estate transaction itself. The real estate transaction just has to be the but-for cause of this ability to make the refusal.
Well, I mean, that would be a generous interpretation of in connection with, but I mean, there is some room, I guess, to have a discussion about the closeness or the nexus that there needs to be. But then, I guess, I look to Section 502, and every other subsection appears to describe something that happens at, before, or at the time of the real estate transaction. So Section A talks about engaging in the real estate transaction in the first place. Subsection C, refuse to receive or fail to transmit a bona fide offer to engage in a transaction. D, refusing to negotiate a transaction. C, telling a person that the property is not available for inspection when it is, or not bringing a listing to somebody's attention. I'm sorry, that's under E. F talks about the documents that are printed and published, or forms used for the transaction. G's, offering, soliciting, accepting, using, or retaining a listing. H is the brokering or appraising of real property. I mean, if the legislature wanted to do any more, they'd have to put up billboards and say, this is all about just the transaction. What else could they do?
Well, here's what they did. They defined real estate transaction to mean sale, exchange, rental, or lease of real property or an interest therein. And then subsection B, the actual subsection of that 502 that matters
Hold on,
here.
let's talk about the definition.
Mhm.
What does that do to undermine what I just said?
Well, as I said in my
Type of transaction, it could be a sale, an exchange, a rental, or a lease. Those are the types of transactions that the legislature is focused on.
Correct, Your Honor, and as I said in the opening, there is actually an ongoing exchange here. We pay a regular condo fee, the condo association takes that fee.
But that's not, I mean, I understand that. I used to live in a condo, I had to pay that fee. That's regulated by the Condominium Act, which you've already referenced. You're telling me this statute regulates the condominium association and its ability to collect fees and its obligations and duties under the law?
I think so, Your Honor, because 501E also defines real property to include an interest in a condominium. So it's not as though the legislature did not anticipate that both of these acts might apply to condominiums. And the Condominium Act is in some ways broader than and in other ways narrower than the protections of the PWD-CRA. It is broader because it doesn't just protect occupants or residents the way that the civil rights laws do. It also would protect you if you had a regular visitor that had a disability. And the legislature's determination, we believe on that basis, is that it recognized that for a condo, it's a different kind of property interest than in a rental. So long as you even have a regular visitor, the protections of the Condominium Act apply.
Your obligations with condos are completely different. With every other type of property, you agree with me, the legislature was focused on the transaction. But with condos, even though they don't spell out condos specifically, they intended to create an ongoing obligation. That's your position?
Yes, but they did spell out condo specifically in 501E. And when you're talking about a transaction that can mean an exchange or an interest in the exchange, and what we have here is an ongoing fee, much like a rental agreement, reading the statute a different way and not allowing this post.
Let me just be specific. I mean, you talk about real property including, of course, real property includes a condo. And they say that here in a mobile home, et cetera, but with condos, we're to understand that that's the only one that has an ongoing obligation, even though they don't spell that out specifically.
We don't think that it's the only one that has an ongoing obligation, Your Honor. We also think there's an ongoing obligation with rentals and leases. Otherwise, there's no meaning to the phrase to the protection in 502(1) that protects a person residing in or intending to reside in a dwelling after it is sold. It is hard to imagine, under the interpretation of the lower courts and the defendants here, who is currently residing in a building after it is sold that could then bring this claim if it was limited to the time of the transaction. I would like to give, if this line of questioning is done, I'd like to give the state some time and then have whatever is remainder for my rebuttal.
Please.
Your Honors, Chris Allen, Assistant Solicitor General on behalf of the Michigan Department of Civil Rights and the Civil Rights Commission. For decades, the department has understood the Persons with Disabilities Civil Rights Act applies before, at the time of, and particularly here after a transaction for real property. As a practical matter, the department and the Fair Housing Center see these kind of post-acquisition claims really more than any other when it comes to discrimination against disabled individuals in housing. The federal fair housing amendments, which these Michigan provisions are modeled on, universally are recognized to apply to post-acquisition claims. And so given the similarity of the state and the federal statutes and their text and their operation, Michigan's protections are substantially equivalent to those same federal protections in the Fair Housing Act. As a result, through the Fair Housing Assistance Program, the department is charged and granted funding to investigate and conciliate claims like this on a regular basis. The Court of Appeals decision here upended this understanding and jeopardizes the department's status in that program. In response to your question, Justice Viviano, about the nature of the real estate transaction, I think it's important to note that in the different type of property interests here sort of delineate whether there will be a post-acquisition claim available. So in the typical sale of a single-family home, where the the seller signs on the dotted line and rides off into the sunset, they're not going to have any post-acquisition claims against them, obviously, because there's no property right left. But where the transaction is an exchange or a rental, a lease, where there is this ongoing relationship, then that sort of differentiates the matter. I'd like to leave the remainder of my time to Mr. Woofter for rebuttal.
Good afternoon, Your Honors. Drew Broadus for the Boulder Bluff defendants. I'd like to point out I also have Mr. Bosch for the other defendants. I'd like to leave him 5 minutes at the end of my time. I'm going to begin with the mootness argument, not because I don't care about the statute, because I don't think it's important. I just think my statutory argument's very simple. It's different from the federal statute. There's a critical phrase that's in our statute that's not in the federal one, and all of the amicus arguments and plaintiff's arguments really boil down to look at the federal statute, and the language is not the same. But the Sixth Circuit ruling with the same parties or the same facts rendered whatever happens here an advisory opinion for a very simple reason. Whatever the outcome, and I'm not saying I don't care about the outcome, I think this opinion should be affirmed, but whether it's affirmed or reversed or something in between, when we go back to the trial court, my motion is the same. And it's based on the Sixth Circuit opinion that has found that there's no case here under Rule 56. And this wasn't an issue that they just sort of haphazardly decided. There was a suggestion by one of the amicus that it's really not entitled to deference somehow. But I mean, this is a case where the Western District wrote a 23-page opinion after a very long hearing. The Sixth Circuit wrote a substantial opinion. There may be some small exception. And I'm not asking the court to decide this, but what I am pointing out is that's a real problem for what this court has to do. And I have some ideas about how that should play out. I suppose one would be to simply deny leave. If there is still some concern about this published opinion, obviously that leaves that out there. Maybe a possibility is holding this in abeyance, directing the trial court to decide this. I would like to point out I did try to raise it in the trial court. It's important to note that these were on separate tracks. The Western District didn't decide this until after the Court of Appeals had already granted the leave application. Now, I did make the argument the trial judge had stayed himself. He wasn't under a stay by the Court of Appeals, so I asked him to remove his own stay and decide whether this was collaterally stopped. He declined. He said he wanted to let the appeal play out, his discretion. So we filed that motion, and then I pointed out to the Court of Appeals as well in a motion. So this isn't an issue where it wasn't raised or wasn't preserved. Obviously, we couldn't raise an affirmative defense that wasn't available factually at the time that we answered it in state court. So there's a real problem here, because there's a possibility of inconsistent outcomes unless the state court proceeding is dismissed, and whether that's dismissed on the Condominium Act claim or both, that's the same argument in the trial court. And that's the problem. But And I'm just a little bit perplexed. Remarkably little has been said about that. The plaintiff simply said procedurally we're not in the right place to bring it up, which there's some truth to that, but doesn't mean you ignore it. One of the amicus kind of just ignored it. The other said it's a bad decision. I would also point out too the argument that's not in the record. Obviously you can take judicial notice. So this court, just like a trial court, could take judicial notice of something like this. If you can't take judicial notice of a Sixth Circuit opinion that's in the federal appendix, I'm not sure what you can. But circling back around to the statute, really everything we've heard from the plaintiffs and the amicus is arguments for the legislature. If this upended some long-standing understanding of how the statute is supposed to work, for one, the case law and the secondary authorities have been remarkably silent. This published opinion is not particularly young. It's from October or November of 2020, so we've had 14 months to talk about it. I just looked it up on Westlaw. I think you'd find the same on Lexis if you prefer. The only thing that comes up are the various orders generated in this appeal. There's no case law really talking about it other than perhaps for standard of review. There's no real criticism. Again, that's an odd argument. It's ultimately a policy argument that really only comes into play if there's an ambiguity, which I submit there's not for reasons Justice Viviano accurately noted. I think this really rises and falls with the fact that when you compare 37.1506A parens 1 to its federal counterpart 3604 F3, the phrase in connection with the real estate transactions is not there in the federal statute. That's why we have federal case law that reaches a different result. And if that's a problem for the Civil Rights Commissioner for the Fair Housing association, their redress is the legislature. It's not an ambiguous statute. The courts really can only do so much with that. And so I'm prepared to address questions or turn it over to Mr. Bosch.
I don't see any questions. Yeah, you may
Thank you.
turn over the podium. Thank you.
Good morning, Your Honors. Peter Bosch on behalf of the Giroux Management Company. First of all, I want to say that this boot on my right leg is not a prop for this case. I actually am recovering from a broken right ankle. I think I just want to make 2 quick points. I think counsel had indicated properly that this statute applies to real estate transactions. I know appellant's counsel wants to say that there's some ongoing obligation, and perhaps it's limited to condo associations. I live in a homeowners association. We don't pay condo dues. We pay $150 a year for our homeowners association. Does it now apply to that association that takes care of our Christmas lights at the entrances? We have a small board that enforces the rules and regulations. What if one of those regulations says you can't have your cars parked outside for months and months, and I have a handicap van that doesn't fit in my garage? Does this statute now apply? There may be others that do, but I think it's not this court's function to broaden the statute past its plain meaning. I think the circuit court determined that, the Court of Appeals did, and I think this court should as well. I think there's a secondary argument that applies to my client. I cited in our brief the Sable Palm condominiums case. We're just a management company. This is the old adage that don't shoot the messenger. We didn't have a say in what happened here. We didn't make the determination. We just said, hey, they want a railing. We actually supported it, and then when the board said no, we informed them of that. We're a conduit. We're the messenger, and we're being dragged in. We had no say. We actually supported their request because we thought it was reasonable. We shouldn't be in this lawsuit. So for both those reasons, at least as it pertains to my client, I believe the lower court and the Court of Appeals decision should be upheld. Any questions? Thank you.
Seeing none.
Thank you, Your Honors. I know my time is brief. I would like to make 2 small points. First, there is no small irony here that defendants are concerned with inconsistent rulings when they ask the court to find that the PWD CRA does not apply post-acquisition, when at the same time the federal corollary does precisely the opposite. Second, there is no judgment for this court to review on the question of the management company's responsibility. And that's all I have. Thank you.
Thank you all. The case will be submitted.